SJC-13068 in the matter of an impounded case.
Attorney Bornstein.
Good morning. Good morning, Chief Justice Budd, honorable justices of the Supreme Judicial Court. My name is Devorah Vester Bornstein, and I represent PR, the appellant, who is attending the session virtually. So the trial judge's ruling on PR's objection to Dr. Fishman's hearsay testimony regarding his past residence illustrates exactly why minors' due process holdings regarding least restrictive alternative and factual findings apply to civil commitments under sections 7 and 8 and are necessary to ensure due process. This is what the trial judge said. Here's what I'm going to do. I'm going to allow the testimony. You can cross on it and obviously argue whether or not it is reliable enough when it comes to no less restrictive means. But I think I need the information.
Ms. Bornstein, do we have any case law that informs us what we should do when the trial judge asks for the information? Because as you well know from Hamey and DYS versus a juvenile, in some of our later cases, it's admissible on cross-examination, correct? That's what we've traditionally said, but I don't know if we've ever confronted the issue when the finder of fact here, the trial judge, is the one who raises the issue. How does that play into it?
Yes, Your Honor. So my brother did cite in his brief the case Commonwealth versus Lucien, which says that the judge can ask questions. However, the judge cannot act partisan in nature. And if the judge asks questions on direct that require that the expert reveal the factual underpinnings of her opinion, I would say that that is indeed partisan, because that is not permitted on direct. So what the petitioner cannot do, I would submit to this court, the judge can't do on direct either, because that undermines.
The judge is the one that's responsible for fact finding. I mean, having been a trial judge, having motions to suppress and the like, it's a quite a different scenario than when you're when the jury decides facts and you leave it to the lawyers. And again, I know that Mr. Kim cited the cases that say judges can ask questions, but how is it the judge being a partisan? It's kind of a strong accusation.
Well, the reason why I mentioned that is because if the hospital can't ask the expert on direct for the factual basis of her opinion, I submit that the judge can't do that either. The judge can ask questions to clarify, and the judge in this case did ask for the not the basis, but where what the source of Dr. Fishman's information was, and that did not undermine PR's right to, on cross, ask whatever questions he would want to ask.
Thank you, Ms. Bourne. You've answered my question. Thank you.
Thank you. So the judge wanted information, and this leads me.
Excuse me, could I just want to ask a follow-up to Justice Gaziano's question. What about the statement in Department of Youth Services, which says it is within the court's discretion to require an initial disclosure of underlying facts or data? Is that initial disclosure, is that referencing on direct? Or what does that mean, that statement in Department of Youth Services?
Your Honor, it's my recollection that that part from DYS versus the juvenile refers to the proposed rule under 705. I don't believe that it is possible for the judge to ask on direct for the factual underpinnings of the expert's opinion. So I do think there's a difference. The
Ms. Bornstein, I'm going to help you out with that answer and then ask you a follow-up question. That's when the judge is the judge of the law and making sure there's a basis for the expert's opinion away from the trier of fact. In response to Justice Kafka's question. But isn't the problem here that the judge, as the trier of fact, is hearing the basis for the opinion that is based on evidence that's not admissible? It might be independently admissible if you had the right source, but it's not admissible And so the judge as the trier of fact is taking that evidence not to understand the basis for the opinion, but to build into whether or not there's sufficient evidence.
I don't agree.
Well, you should, because I think it helps you.
I'm sorry. In this case, the trial judge asked for, after Dr. Fishman testified to the inadmissible hearsay, the trial judge asked where she got that.
Right, and that's the problem, because the judge is hearing what he, as the trier of fact, can't hear, which is the basis for the opinion actually substantively.
Well, that, yes, he already heard the basis. It was only a little while later when he asked what the source of the information was, but he had already heard the inadmissible hearsay testimony that was allegedly based on something in the record which the hospital hadn't even introduced. So that already got out. It was only later that he asked about the source. Where did this come from? And Dr. Fishman explained it came from our social worker, whom she believes was in contact with the prior treater. We don't know if, and again, we don't need to go to a Bucci or a Doyle analysis because the record wasn't introduced. So all of that doesn't come in. And
Right, that's the problem, because he's the judge of the facts and the judge of the law there.
correct, everything that flowed from that initial hearsay testimony. And so the reason why this is all important is because if we look at Nassar and Minor, while they may come to the same conclusion, they give different guidance. And that's really critical here. In Nassar, this court has interpreted the language of Nassar to mean that a court cannot commit a person before finding that no less restrictive alternative is appropriate. However, Nassar doesn't define appropriate, Minor does. And Minor says to be appropriate, the less restrictive alternative need not eliminate all risk. It just needs to bring the risk of harm below the statutory threshold that is defined in Section 1 of the statute.
I'm confused by that. So we have a very high standard of proof here, beyond a reasonable doubt, right? We have the rules of evidence apply, or we wouldn't be struggling with some of these other issues. In criminal trials, we convict all the time without specific fact findings. So why are we going to impose specific fact finding here when we have a beyond a reasonable doubt the standard, we have the rules of evidence, we have appointed counsel, we have all these due process protections here?
I would say, Justice Cocker, that the burden of proof in this case is not dispositive in the analysis. And that's because the burden of proof is the quantum of evidence. It regards the degree of confidence that the fact finder should have in the correctness of the factual conclusions. And that's different from findings, because findings are the evidence that the trial court credits regarding the ultimate legal conclusion. And on review, even if we have a high burden of proof, that's not going to protect against erroneous findings or an erroneous application of the law to the facts. And indeed—
Counsel, could I interrupt you on that point?
Yes.
In a lot of times, these hearings, when the presiding judge goes to render their conclusions, they'll say something like that they credit the doctor's testimony that testified at the hearing. And if that's in the record, why doesn't that suffice?
It doesn't suffice. It doesn't suffice if the court is not making factual findings on each material element, because we have three material elements here. We have the mental health, the mental illness, we have the likelihood of serious harm, and we have no less restrictive alternative, which, by the way, is also built into prong 3, as you know. And so
sure, but the way these hearings go, The petitioner, the facility is represented by counsel. They qualify the doctor. And a lot of times there's a stipulation as to the underlying mental condition. And then we move on to the whether it's prong 1, 2, or 3. And all of these bases that the hospital needs to cover to sustain their burden, they elicit that testimony, not only about the underlying mental condition, but whether or not they've satisfied prongs 1, 2, or 3, and then moving on to whether or not there's no less restrictive means to accomplish these things. And if the doctor testifies to all of that, and at the end of all of that, when the evidence closed, I'm just wondering, why isn't that enough to satisfy the fact finding to say, I credit what the doctor has testified to?
Because, Your Honor, we need more. Minor instructs us that we need more than just an expert opinion. We need facts. We need actual facts so that the trial court can meaningfully consider all less restrictive alternatives. And this court did say in Minor that that we need these factual findings because these cases are so intensely fact specific, and there's no way to ensure that commitment is the least restrictive means of vindicating the government's interest.
That was written in context of Section 35, which is a much more informal proceeding. Isn't this really a sufficiency of evidence issue? Because if the facts are there, these are subject to review, and that in fact happened by the appellate division of the BMC in this case. I mean, to give you an example, in Zanetti, when we talked about the necessity for joint venture versus principal liability, this court said, well, we're going to review the record, and if it's there, it's there. That's a murder conviction. So aren't all those protections afforded to you when we have a sufficiency review after the hearing?
No, Your Honor, and this is the reason why. First of all, 7 and 8 commitment hearings are not like criminal trials or criminal bench trials. Why? Because the goals and the evidence are different. In a criminal trial, we are looking backwards. The fact finder is looking to see whether a person committed a crime in the past based on specifically pled elements, whereby in a civil commitment, the fact finder is looking ahead. It's a prospective assessment of future risk. The trial court judge has to determine whether this person is going to behave in a certain way in the future, in the imminent future. And so he has to consider a lot of fact-intensive factors that are fluid. And he also has to determine whether or not there's a least restrictive alternative, which we don't have in a criminal trial. And what's important to note is that when we have a sufficiency case in the commitment arena, if we don't have findings of fact, then on review, the reviewing court is really creating a legal fiction. Because if we don't know what the trial
I think the findings of fact, you use Justice George's as hypothetical. He posits when the judge says, I credit what the expert had to say, right? Because I understand your point. If there's conflicting testimony, then who knows, right, on review. But here, the hypothetical posed, at least by Justice George's, was the trial judge credits the expert from the hospital.
Well, Your Honor, that happens very rarely, to be honest. In most of our cases, if not all of our cases, we don't have that on the record. We don't have the trial court saying, I credit X, Y, and Z. What we're left with is just literally a kitchen sink of facts on review. And indeed, the appellate division in this case, if you look at the record appendix on page 19, it said that the trial court credited Dr. Fishman's testimony and her opinion that PR would pose a very substantial risk of harm due to mental illness because he needed supervision due to his psychotic delusions, et cetera. That doesn't appear in the record. We don't know what the trial court credited when
Bernstein, could I before we lose you, I don't know if you had a chance to read the amicus from Attorney Schiavone, but I'm sure you did. To summarize it, it basically said this is going to be a disaster if if judges have to make these type of findings. And he listed out all the reasons, and then he pointed out that in our NL case with the continuances, that he suggested, done some unintended harm to patients, to managing facilities, and then here with the bifurcated hearing, that, and the judges have to get back to first session, that he was basically saying, your position is going to be a real-world disaster. Any response to that?
Yes, it will not be a real world disaster. First of all, the judge has the option under minor to make the findings orally. Secondly, if the judge decides to make written findings, there's nothing preventing the judge from entering commitment order and then issuing those written findings some days later. The court has 10 days under the statute to even issue that commitment order. But the judge can bifurcate it. The judge can commit the person, but then later on issue the written findings. And courts do that all the time. They do that in termination cases. They have up until 90 days to issue written findings after they've issued the termination judgment. So this is not going to cause havoc. In fact, it's good for everybody.
Didn't the amicus argue, because there's a two-step process, the commitment and then the treatment, that this is going to hold up the ability to deal with the treatment?
Absolutely not. Oh, I'm sorry.
No, go ahead. So what's your response to that?
My response to that, Justice Kafka, is that it will not cause havoc with regard to 8B. It won't cause havoc because, as I just said, the judge, after the commitment hearing, if he finds that all of the material elements have been met beyond a reasonable doubt, he can issue the commitment order. And that's the only requirement to hold an 8B hearing.
So he can issue the commitment order without the fact finding you're talking about, or with the fact finding you're talking about?
Well, under minor, the judge has an option. The judge can make findings orally, which would then be right after he issues the order. Or if the court decides that it wants to wait with the findings because it wants to issue written findings, there's nothing stopping the judge from issuing the commitment order. And then afterwards, the 8B can proceed.
So that they can start the treatment, even though the fact findings haven't been made, they can start the treatment without the fact findings, that they're able to proceed with treatment, or because the amicus argues they can't.
I would argue the opposite. The statute says that an 8B, the court cannot commence a hearing on an 8B petition unless there's a commitment order. It doesn't speak about findings. Findings are separate. And the findings.
But aren't you saying you can't have one without the other? Isn't that the whole thrust of your argument? That you need the findings to make the commitment order legitimate?
Correct. But minor gives the trial court the option of stating orally what it has found, what the subsidiary facts are that support the ultimate legal conclusions, or to put those findings in writing. And in a section 35, I would argue that because it's so fast paced and the person is then, if the person's committed and is taken to the treatment center, if the judge opts in that case to issue written findings, I would say there's not a lot of time for the judge to do that. So the judge issues the order, the person is sent to the treatment center, and afterwards the judge issues finding. I would say in a reasonable amount of time. But I don't think there's anything in the law, in this decision, that would preclude a trial court from bifurcating that if it chose to issue the written findings.
Attorney Bornstein, let me just ask you one final question before you're done. Do you agree that, as Justice George has posed, if in fact going forward a judge were to say, I credit the expert's testimony, we would take care of this?
No, I don't agree. I don't think it's enough. I would submit.
Why isn't it? If the testimony is there on the record and it has all of the elements necessary, why wouldn't that be enough?
It wouldn't be enough if the expert just testified to her opinion. An opinion is not fact. An opinion goes to the ultimate legal conclusion. And the trial court, especially with regard to least restrictive alternative, needs to know what, if the ultimate conclusion is no less restrictive alternative, the trial court judge needs to know what was done. It's important to know how a hospital got there, because otherwise there is no way to even apply a burden of proof to the ultimate conclusion, no less
But that
restrictive.
doesn't go to the findings, does it? That doesn't really go to the judge's findings of fact about why, why the order is as the judge says it should be.
I guess I'm not
Right.
Yeah.
I guess all I'm saying is I can imagine that going forward, a judge would have the option of doing written findings or saying, I credit the expert's testimony. Based on that testimony, here's my order and here's, why not?
Chief, may I ask one follow-up question?
If it's going to clarify mine, yeah.
Counsel, with respect to the chief's question, we're also presuming that the only witness testifying at these hearings is the treating physician. There's also plenty of times where there are family members that come in that testify to the history of mental illness, some of the perhaps violent outbursts that led to usually some of these things come in through a Section 12, and then there's a referral to the psychiatric units. There are other witnesses that testify at these hearings all the time that testify to the likelihood of imminent harm and whether or not they could return to the community, whether they could come back to the home or to the facility where they were living. They come in all the time. And I'm just, again, wondering why, if the judge were to say, I heard this testimony and I credit the social worker, I credit the mother, I credit the doctor that's testifying that all of these bases are covered, why isn't that enough?
It would be enough, Your Honor, if the testimony was factual so that the reviewing court knew exactly what the subsidiary facts were that supported the ultimate conclusions. In that case, it would be fine. It would be clear. What we want is transparency. That's the goal. This is the fact findings requirement is not just for respondent. It's really for everybody. It's for the hospital. It's for the reviewing court especially, because how can you review for error if you don't have the factual findings? And also, how can you review for sufficiency if you defer to the trial court for the on the findings, but you scrutinize without deference with regard to the legal criteria the court applied? How do you know what to apply it to? In this case, we have a perfect example because the appellate division assumed that the trial court found harm because it credited Dr. Fishman's testimony regarding delusions and poor judgment and et cetera, which, by the way, don't make out harm. They just go to the mental illness and PR's baseline. But apart from that, how can a reviewing court be effective and accurate in its review where it's basically creating a legal fiction out of a kitchen sink of facts? That's all I'm saying, is that the reviewing court really needs to have these facts, and because these cases are so fact intensive and depend on an accurate assessment of whether or not a person in the near future, days or weeks, is going to be a likelihood of serious harm as a result of a mental illness. We need the facts, and they help everybody.
Okay, thank you so much.
Thank you, Your Honor.
Kim.
Good morning. May it please the court, Assistant Attorney General David Kim on behalf of the appellee. This is an appeal of a Section 7-8 proceeding where the department showed at the trial court the following facts, and these were not just conclusory opinions by an expert, but specific facts that the patient had paranoid schizophrenia, they suffered major delusions because of that schizophrenia, and those delusions led to incredibly dangerous behaviors, such as refusing medication and at one point increasing the intake of the oxygen for his COPD treatment to potentially lethal levels. Moreover,
Well, why shouldn't we treat Section 8 commitment similar to the way we treat Section 35 under minor?
so this court has for many years treated Section 35 and Section 7 and 8 very differently for constitutional purposes. The primary reason, as stated in GP, seems to be the length of the detention involved. And so in Section 35 cases, hearsay evidence is admissible. And a lot of the petitioners are pro se. And so these are much more informal proceedings, and they require a different set of due process protections. And that was really the animating concern of minor. How do we know that the evidence that the judge relied upon was reliable? Well, let's get courts to put down on the record which evidence they found reliable so that we can actually review. In Section 7 and 8 proceedings, the rules of evidence apply. And so there is this baseline presumption that all the evidence being considered by the judge is at a minimum relevant and competent. That concern doesn't really exist. Section 7 and 8 proceedings have really been treated more like criminal bench trials historically. And so in that context, as Justice Gaziano pointed out, even when you have life without parole at stake, where you have alternative theories for liability on a murder charge, these findings are not required where it's a bench trial. So in this context, what we have is a record that honestly is not very much.
Counsel, can I ask you to address opposing counsel's argument that the salient difference between a criminal trial and the civil commitment is that the civil commitment is forward-looking, whereas the criminal trial is deciding things that happened in the past? Why isn't that the differentiating criteria between how we treat civil commitments versus criminal trials?
Well, I'm not aware of a case that particular difference makes a difference in terms of the due process protections at stake. The question really is the evidence reliable enough and the standard of proof high enough to ensure that we are making the correct determination when detaining a person for a lengthy period of time.
And what is the case that says that?
So Hagberg sets out the beyond a reasonable doubt standard for 7 and 8 cases, actually all cases involving mental illness. And that's an actually higher standard of proof than what's required by federal law, which is clear and convincing evidence. And Nassar sets out the requirement that there's no less restrictive alternative to civil commitment, involuntary commitment in these kinds of cases. And so this set, and by the way, that protection was not there until minor for Section 35 cases, which is just another sign that, again, these two kinds of proceedings were treated very differently for due process purposes. This point is made actually explicit.
Haven't we said in the past, I mean, before minor, we'd said in the past that 7 and 8 proceedings without fact findings satisfy due process, right? I mean, we've said that 7 and 8 in the past satisfies due process. The only issue is whether the statement we said in minor about 35 requires us to change our mind about whether 7 and 8 meet due process without specific findings, right?
That's true, Your Honor. And not only that, a couple of years ago in the MC case, this court decided that an incomplete transcript in a civil commitment proceeding was a sufficient record for appellate review. And in that case, the incomplete transcript was because of technical issues with the recording equipment. And so if that's enough for a reviewing court to decide what the factual issues were at play, then it should go without saying that here we have a complete transcript. The only question is what evidence was relied upon. But again, we have a complete record, so that should be more than enough for, under our law, for a reviewing court to decide whether this is a constitutionally sound decision.
Do Could you address the evidentiary issue, particularly the judge sort of getting into the underlying factual issues on direct, as opposed to letting this play out at cross?
Yes, so I start off by saying that at worst, this was harmless error. The evidence at the hearing was actually that this individual was not safe even in an assisted living facility. He still suffered from the delusions that led to him increasing his oxygen intake, which happened at an assisted living facility. So clearly, even under that situation, he was posing a risk of harm to himself. And so
That wasn't related to mental illness, though.
I don't really understand the question.
Well, you're saying that the substantial harm because of the medical issue. Right?
Oh, yes, but the harm was related to his delusions about what kind of treatment he needed for his COPD. And those delusions were stemming from his paranoid schizophrenia.
That's a fair point.
Attorney Kim, in this particular case, do you remember what prong the facility was moving under? I didn't catch that in the record, but was it all three or is it any one particular?
So in the record is a bit mixed on this. In the initial petition, it does seem to be potential harm to others. But by the time we get to the commitment proceeding, the theory is very much that he cannot protect himself in the community. So prong 3.
And there are different standards in those three prongs, right?
Correct, yes.
And does that at all factor into this decision here?
It matters insofar as the question for prong 3 is whether the patient has the ability to protect themselves in the community. So that's very much a central question, even before getting to less restrictive alternatives.
Mm-hmm.
That's a central question. And so to get to that question, the court here sort of intervened in the direct examination and started soliciting answers out of this expert witness. But again, ultimately, the record is pretty clear that whether this facility was available or not was neither here nor there, because this person would have posed a threat to themselves at that facility anyway. But if we do reach the legal question about whether this was an abuse of discretion, first of all, this evidence was independently admissible. The Chappell case defines independently admissible as, it would be admissible, but for the correct witness or foundation. So here, the correct witness would have been the individual at that other facility who said, we don't have any more beds, we don't have any more spots. We could have brought that person in. The facility could have laid the foundation to introduce the medical records, which were admissible under the statutory medical records.
I'm not sure that's really contested. That's true. I think the concern is that for substantively that it went into the mix.
Well,
that it was a factor as to, I think, the third prong.
Right. So it wasn't a backdoor in the sense that our evidentiary law worries about the backdoor that people are that the courts have been worried about when setting down this rule is that the proponent of the evidence would introduce inadmissible evidence or evidence that's not been properly founded into the record. That's not what happened here. It's not the proponent of the evidence doing it. It's the court at various points saying, counsel, ask your witness this specific question, or in a couple of cases, the court directly asking the witness the question. And so in those instances, whether this is the best way to do it or not, the point is that our evidentiary law does not prohibit this exact chain of events that occurred here. And it's not, it wasn't legal error for the court to handle the situation this way.
So, but you want us to issue a ruling that's saying that's okay, or that it's ill-advised, but okay? What are, because that's a pretty important step. Are we going to allow judges to do that or not?
Well, so again, I think at a minimum, the court doesn't even need to wade into this evidentiary question because I think it was harmless error. but we're the
I
court to
get-
wade in.
I get that, but I guess, Justice Gaziano's initial question, do we have any case law on this? It sounds like we don't.
Not on this specific, yeah, not on this specific question of whether a court can do this or not. The case law that exists is about direct versus cross-examination.
But isn't it a big deal if the judge is doing it as the trier of fact?
Well, section 614 in the Lucian case, the Massachusetts Guide to Evidence states that a trier of fact, the judge is allowed to ask these questions so long as they are not partisan. And in this case, the questioning was not partisan. It was just to get these facts on the record. The judge didn't have any knowledge beforehand whether the evidence was favorable to one party or the other. It very well could have been favorable to the patient. And so, those.
By the way, isn't it? I mean, I understand that we like this played out on cross, but this seems artificial. Isn't it right for the judge to want to know what the basis of that statement is? I'm just not sure Judge Tynes made any error in asking that. I mean, it seems a good question. So that's what troubles me, that we seem to be saying that it's inappropriate, but it's something the judge is going to want to know, right?
I agree, Your Honor. It's an essential element of Section 7 and 8 civil commitments. And I think there's a bit of an irony that the appellant is asking for this constitutional basis for a court going into this inquiry about whether there was a less restrictive alternative or not. And the trial court did that here. The trial court went into that inquiry, but now that's considered error.
Well,
So,
they don't mind that there's evidence to support it if it is. They just want it to be based on competent evidence. I don't think their position's unreasonable. It's just that they're concerned that the basis for the opinion, which can be utilized if it would be independently admissible, shouldn't be baked into the cake as to the sufficiency. So I don't think their position's inconsistent.
I would also say that, it's
But
not.
isn't it related to whether, the expert's credibility in general, the thought process of the expert here? I mean, I get that there may be some kind of, we've sort of backed ourselves into a corner with the rule we've got on allowing this only into cross, but I don't know if it makes any sense to not be able to ask this question.
Yeah, I agree with the basic contention that as a general rule, this evidence should only come in on cross. And, it's really up to the discretion of the court whether they're going to ask these questions or not to get at the basis. They could leave the facility out to dry and say, we're not going to get any of this evidence in. Either you find a way to get it in, or
Well, isn't
your
the
case is
answer
not
to
made.
trust our judges to compartmentalize their mind and be able to differentiate between credibility issues as the trier of fact and as the judge of the law to be able to ensure that there's a basis for an opinion? And so that the judge is able to ask those type of questions? And we just trust trial judges to be able to differentiate between the two roles.
Yeah, I agree with that, Your Honor. It's there should be this presumption that when trial courts wade into this territory, that they're able to compartmentalize between different elements, different kinds of questions between substantive evidence or the credibility of witnesses. And there's no indication on this record that the trial court mangled any of those distinctions. The only thing the trial court did here was, again, intervene during a direct examination and get this evidence onto the record.
Okay, does anyone have any further questions? Thank you so much.
Thank you.